actually are the most brilliant possible, no one. Okay, so I'm very brief necessarily because I think this is a marvelous initiative by the students, and I think the audience should talk more than we do. But let me just say 4 things. Actually, I'll say only 3 things. I'm going to leave out number 3 to some extent because Gloria has covered that. I'm going to say a word about official secrets laws because that's what this is. Where the bill comes from. I want to say something about how it, well, I won't say much about how it works, and I'll just talk very briefly about the objections and offer a perspective for how to look at those objections. Some of the objections are well taken, and the bill is not, as it currently stands, it's not constitutional, but it can be fixed. It can actually rather easily be fixed, and indeed needs to be. The reason is you have to have official secrets legislation. The bill will replace the existing current official secrets regime. There is such a regime in place, and it just won't do it. It's simply unconstitutional as it stands. The law on this is set out to call it the international standard of it. It's in the ICCPR Article 19, which you have none of us reading there. I'll read it for you. It's talking about the right to receive information, the right of freedom of information, essentially. And it says such a right is subject to certain restrictions as provided by law as necessary for the respect of the rights of others or for the protection of national security. That's Article 19 of the ICCPR. Official secrets laws exist in all democracies, and for a very good reason. You need to have a law that covers, that constrains, that regulates the process by which some things are labeled as secret and are therefore prevented from being subject to free circulation, to freedom of information. You need a law. And the law obviously must be subject to constitutional constraints. And it must perform a very difficult task, which is to strike a balance. Conflict is inevitable. Okay. Secrets are in conflict with freedom of information. It's just so. The point is how to strike a balance between these 2 competing principles. The need to protect the national interest and the rights of others, and in so doing to restrict the freedom of information as little as possible in order to achieve a properly functioning democracy. This is WikiLeaks. If you go to it at the moment, you'll see that, I don't know what's happened to it. I think somebody's kind of hit it with some kind of cyber attack. You can't actually read it anymore. We're just updating. They're not just for days. Anyway, you'll remember the story about this. A whole set, a huge amount of classified information, US classified information about the conduct of the war in Afghanistan, released to the public, contrary to all the laws of the United States. The point that's made in this particular article is the human rights group saying to WikiLeaks, please, you've got to take some of this stuff down. It's dangerous. It's very dangerous for the individuals whose names are mentioned in these documents. They are subject to all sorts of threats, targeting now, because they've been after, as collaborators with the US occupation. Okay. The point that's being made here is very simply that classification can be for a good reason. There's a very good reason for it sometimes. Okay. You need it. And what you therefore need is a law that will strike this balance. The balance between the protection of the rights of others, which is what's going on here, and a properly tailored conception of the national interest. Okay. Where does the bill come from? This is important. The drafting process was begun by the Ministry of Intelligence. In other words, the Ministry of Intelligence in 2007 under the Military Administration. It's not a Polokwane product at all. It's got nothing to do with the decisions taken by the ANC at the conference in Polokwane. It's a process that's been going on for some time to perform the necessary and quite technical task of updating the official secrets regime. It's going to happen because the current law just won't do. The Protection of Information Bill was then submitted in 2008. It was withdrawn. There was considerable objections to the writing of it, and for complex reasons, it was withdrawn. It was then partially redrafted by the parliamentary drafters, and then it's been reintroduced in 2010. So there are 2 versions of the bill, 2008 and 2010. We're now dealing with 2016. The current law is, sorry, it says Protection of Information Act 1982, supplemented by the MISC, the Minimum Information Security Standard. Why change it? It's just pre-constitutional. It doesn't work. And particularly, it has no proper, it doesn't, it in no way complies with either the Constitution or, importantly, the promotion of access to information. The MISC is also inconsistent and it's over-inclusive. Its definitions are simply too wide, resulting in far too too much stuff getting classified. So we saw it today in the paper about how a question was asked in Parliament about President Zuma's flight on Air Force plane, and the answer is, no, you can't see that, it's classified. Okay, that's misclassification, classification under the existing regime. It sounds like a case of over-classification. I don't really see the danger of such information, particularly after you come back, you've already landed. Okay, I'll skip over all of this stuff because we've done it. Oh, I just want to make this point. Please, when dealing with legislation, remember how you read legislation. You read the bill as a whole. You don't just find a little bit in it and say, this is a shocking piece of a flagrant denial of our democracy. You've got to read the whole thing. Okay, it all fits together. It's easy to do this. You go through the bill and you say, oh, I'm shocked. This is terrible. Look at this. You've got to read the whole thing. And you've got to read it perfectly, in accordance with both its stated purposes and with the constitutional requirements. If necessary, you have to kind of bend it to a constitutional purpose. Okay, I'll skip this stuff. You know this already. And I want to talk to, very briefly, the objections. Part one of the objections are what I'll call the tendentious objections. These are the objections, essentially, that this is an assault on democracy, a concerted attack on the press in particular. Okay, and this is like, we're sort of doing the drain. Okay, there are all sorts of examples. I can just show you some of them. This is my